All right, good morning. Welcome to Criminal Procedure. We shall now continue our discussion on Rule 114, bail. So how does the rules of court define bail? The section on Rule 114, Section 1, no, defines bail as the security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions hereinafter specified. Bail may be given in the form of corporate, property, bond, cash deposit, or recognizance. Remember na it is the security given for the temporary release of a person who has been arrested but whose guilt has not yet been proven in court beyond reasonable doubt. Okay? The quantum of proof required in criminal cases is proof beyond or guilt. The proof of his guilt should be beyond reasonable doubt. Okay? Bail is not granted to prevent the accused from committing additional crimes. Ang purpose of bail is to guarantee nga mo-appear good siya in the hearing. Okay? Mo-appear siya during trial. Maunay purpose sa bail, okay? To guarantee his appearance before any court as required under the conditions hereinafter specified. Alright? Now, constitutional basis of the right to bail. Actually, kaning right to bail is a constitutional right, okay? Emphatically, the Philippine Constitution provides that all persons, except those charged with offenses punishable by reclusion perpetua, when evidence of guilt is strong, shall before conviction be bailable by sufficient sureties or be released on recognizance as may be provided by law. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended, and excessive bail shall not be required. That's provided for in your Article 3, Section 13 of the 1987 Philippine Constitution. So the right to bail emanates from the accused constitutional right to be presumed innocent, and it is accorded to a person in custody of the law who may, by reason of the presumption of innocence he enjoys, be allowed provisional liberty upon filing of a security to guarantee his appearance before any court. And kaning presumption of innocence no, is actually rooted in the guarantee of due process and is safeguarded by the constitutional right to be released on bail, and further binds the court to wait until after trial to impose any punishment on the accused. All right? So again, the Constitution lays down the following fundamental tenets on bail. Remember, as a general rule, all persons charged before their conviction of a criminal crime shall be entitled to bail. Later, you will know when is bail a matter of right, when is bail a matter of discretion. At unang tagsa-tagsaon niya, okay? And then further, the suspension of the privilege of the writ of habeas corpus does not impair the right to bail. Excessive bail is not to be required. And then the constitutional provision on bail is substantially reiterated in the rules of court. If you may notice in your section 7, no, niingon diha, na no person charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment shall be admitted to bail when evidence of guilt is strong, regardless of the stage of the criminal prosecution. Okay? Now, taking the Constitution and the rules of court together, the rule, therefore, is that a person shall, before conviction be accorded the right to bail. Okay? So, as a rule, mo gina, before the conviction, he has the right to bail. Unless no, ang charge sa iyaha is a capital offense, or ang offense is punishable by either reclusion perpetua or life imprisonment, and the evidence of guilt is strong. Okay? The grant or the denial of bail to a person charged with an offense punishable by at least reclusion perpetua or life imprisonment is made dependent on whether or not the evidence of guilt is strong. So, diri mabutang nga ang bail becomes discretionary. Okay? If you are charged with an offense in the RTC and the imposable penalty no, is either reclusion perpetua or life imprisonment, you have to prove that the evidence of guilt is not strong so that you'll be allowed bail. Diha, atong tawag ana is bail as a matter of discretion. Okay? So tao ni judge, ang ebidensya ba sa prosecution is weak or is it strong? If it's strong, the bail will not be granted. If it's weak, no, the bail will be granted by the court. Diha musod ang bail as a matter of discretion. Okay? Kaning rule would apply, for instance, no, kanang rape or kodeta cases. Kay kaning rape o kodeta ang punishment ani when you go through your criminal law too, no, is reclusion perpetua man. And there's no distinction kung this is made in a political complexion or of a moral turpitude involvement, no, in the crime charge. So there's no distinction so long as the imposable penalty is provided for by law is reclusion perpetua or life imprisonment. Musod na diha ang bail as a matter of discretion. You need to see if the evidence of guilt is strong. Okay. Now, the test is not whether the evidence establishes guilt beyond reasonable doubt, but rather whether it shows evident guilt or great presumption of guilt. Muna pasabot sa evidence of guilt is strong. Okay. As such, the court is ministerially bound to decide with circumstances and factors are if or which circumstances and factors are which would show evident of guilt or presumption of guilt. Okay. Under the rules of court, particularly in Rule 133, the proof beyond reasonable doubt is the quantum of evidence necessary for conviction, as I've mentioned earlier, not to forfeit the constitutional right to bail, which merely requires that the evidence of guilt be strong. So evidently, strong does not mean proof beyond reasonable doubt. Okay, lahi-lahi na siya nga quantum of proof. Okay. Now, bail in the military, okay? According to the case of Comendador versus Villa, the right to bail has traditionally not been recognized and is not available in the military as an exception to the general rule embodied in the Bill of Rights. The right to a speedy trial is given more emphasis in the military where the right to bail does not exist. The unique structure of the military should be enough reason to exempt military men from the constitutional coverage on the right to bail. The argument that denial from the military of the right to bail would violate the Equal Protection Clause is not acceptable. In the Supreme Court, this guarantee requires equal treatment only of persons or things similarly situated and does not apply where the subject of the treatment is substantially different from the others. So accused officers can complain if they are denied bail and other members of the military are not, but they cannot say they have been discriminated against because they are not allowed the same right that is extended to civilians. So that's what the Supreme Court said in the case of Comendador. So basically, the military does not have the right to bail. Okay? Ningon na Supreme Court makareklamo mo nga gideny mo og bail kung ang ubang membro sa military are given the right to bail and some of you are not. So diha ma-violate ang Equal Protection Clause. But since you are not similar situated as the civilians, no, you cannot say that you have been discriminated against. Okay? Muna giingon sa Supreme Court. Now, is there also a bail in extradition proceedings? In the case of government of the USA versus Porganan, one of the issues presented for resolution was whether or not a person facing extradition is entitled to bail. So the private respondent here maintained that the Philippine Constitution secures the right to bail of all persons, including those sought to be extradited, and the only exception being a person who is charged with an offense punishable with reclusion perpetua when evidence of guilt is strong. Okay. He also maintained that the granting of bail would, among others, be consistent with Section 4 of Rule 114 of the Rules of Court, which provides when bail is a matter of right. On the other hand, the petitioner claims that there's no provision in the Philippine Constitution granting the right to bail to a person who is the subject of an extradition request and arrest warrant. The court agreed with the petitioner and advanced the following reasons. Una, niingon ng Supreme Court, the use of the word conviction in the constitutional provision on bail in Section 13 of Article 3 of the Constitution, as well as Section 4, Rule 114 of the Rules of Court, suggests that bail applies only when a person has been arrested and detained for violation of Philippine criminal laws. It does not apply to extradition proceedings because extradition courts do not render judgments of conviction or acquittal. The constitutional right to bail flows from the presumption of innocence in favor of every accused who should not be subjected to the loss of freedom, as thereafter he would be entitled to acquittal unless his guilt be proved beyond reasonable doubt. It follows, according to the Supreme Court, that the constitutional provision on bail will not apply to a case like extradition, where the presumption of innocence is not at issue. Extradition proceedings, according to the Supreme Court, are not criminal in nature but sui generis, a class in itself. So since it is not a criminal proceeding, it will not call into operation all the rights of an accused under the Bill of Rights and does not involve a determination of guilt or innocence. The court, however, did not hold that bail never applies to extradition cases. Instead, niingon ng Supreme Court nga bail is not a matter of right in extradition cases. However, in the Supreme Court, the judiciary has the constitutional duty to curb grave abuse of discretion and tyranny, as well as the power to promulgate rules to protect and enforce constitutional rights. Furthermore, the right to due process is broad enough to include the grant of basic fairness to extraditees. Indeed, the court stressed that the right to due process extends to the life, liberty, or property of every person. It is dynamic and resilient, adaptable to every situation, calling for its application. Okay? So remember the exception to the no bail rule in extradition proceedings. In establishing an exception to the no bail rule, the court, in the case of the government of USA versus Porganan, said that accordingly and to best serve the ends of justice, we believe and so hold that after a potential extraditee has been arrested or placed under the custody of the law, bail may be applied for and granted as an exception only upon a clear and convincing showing. Tanawa ang quantum of evidence, clear and convincing showing that once granted bail, the applicant will not be a flight risk or a danger to the community. Dapat di siya flight risk. Ikaduha, that there exists special humanitarian and compelling circumstances, including as a matter of reciprocity, those cited by the highest court in requesting state when it grants provisional liberty in extradition cases therein. Okay, so since this exception has no express or specific statutory basis, and since it is derived essentially from general principles of justice and fairness, the applicant bears the burden of proving the above two-tiered requirements with clarity, precision, and emphatic forcefulness. Okay, the court realizes that extradition is basically an executive, not a judicial responsibility arising from the presidential power to conduct foreign relations. In its barest concept, according to the Supreme Court, it partakes of the nature of police assistance among citizens, which is not normally a judicial prerogative. Hence, any intrusion by the courts into the exercise of these power should be characterized by caution, so that the vital international and bilateral interests of our country will not be unreasonably impeded or compromised. So in short, while the court is ever protective of the sporting idea of fair play, it also recognizes the limits of its own prerogatives and the need to fulfill international obligations. Okay? But then, 5 years later, niingon ng Supreme Court in the case of Government of Hong Kong Special Administrative Region versus Eulalia, they ruled anew on the issue as to whether or not bail applies to extradition cases. And it said that while admitting that the ruling in the previous case of Purganan falls squarely to the private respondent's case, the court in Hong Kong versus Eulalia viewed the issue in the light of the modern trend in international law, placing primacy on the worth of the individual person and the sanctity of human rights. So here, gi-consider sa Supreme Court ang ilahang decision, gi-consider sa Supreme Court ang principles of international law. Okay? Specifically, niingon ng Supreme Court nga it cannot ignore the growing importance of the individual person in public international law, who in the 20th century has gradually attained global recognition. and the higher value now being given to human rights in the international sphere, the corresponding duty of countries to observe these universal human rights in fulfilling their treaty obligations, and the duty of the court to balance the rights of the individual under a fundamental law on the other hand, and the law on extradition on one hand. Okay, so the Philippines, yung Supreme Court, along with the other members of the family of nations, is committed to uphold fundamental human rights, as well as value the worth and dignity of every person. So the country has the responsibility of protecting and promoting the right of every person to liberty and due process, in ensuring that those detained or arrested can participate in the proceedings before a court, and to make available to every person under detention such remedies which safeguard their fundamental right to liberty. These remedies include the right to be admitted to bail. And in re-examining Perganan, the Supreme Court made the following observations. Yun sila nga, the exercise of the state's power to deprive an individual of his liberty is not necessarily limited to criminal proceedings. Respondents in administrative proceedings such as deportation and quarantine have likewise been detained. Second, to limit bail to criminal proceedings would be to close our eyes to our jurisprudential history. Yung Supreme Court Philippine jurisprudence has not limited the exercise of the right to bail to criminal proceedings only. And the Supreme Court has admitted to bail persons who are not involved in criminal proceedings. In fact, in the Supreme Court, bail has been allowed in this jurisdiction to persons in detention during the pendency of administrative proceedings, taking into cognizance the obligation of the Philippines under international conventions to uphold human rights. So, noting that bail had in the past been granted in deportation proceedings, the court reasoned that if bail can be granted in deportation cases, it sees no justification why it should not be allowed in extradition cases. Okay. Likewise, considering that the Universal Declaration of Human Rights applies to deportation cases, there's also no reason why it cannot be invoked in extradition cases. So here, no, ang gi-invoke na sa Supreme Court is the principles of international law. Ingon ng Supreme Court, after all, both are administrative proceedings where the innocence or guilt of the person detained is not an issue. Clearly, ingon si Supreme Court, nga the right of a prospective extraditee to apply for bail in this jurisdiction must be viewed in the light of the various treaty obligations of the Philippines concerning respect for promotion and protection of human rights. Under these treaties, the presumption lies in favor of human liberty. Therefore, the Philippines should see to it that the right to liberty of every person is not impaired. So mao na gihimong rason sa Supreme Court why they re-examined the decision in the government of USA versus Perganan. Okay. Now, Section 2 provides the conditions of bail. All kinds of bail are subject to the following conditions. So, number one, the undertaking shall be effective upon approval and unless canceled, shall remain in force at all stages of the case until promulgation of the judgment of the regional trial court, irrespective whether the case was originally filed in or appealed to it. The accused shall appear before the proper court whenever required by the court. Of these rules, the failure of the accused to appear in the trial without justification and due notice shall be deemed a waiver of his right to be present thereat, and in such case, a trial may proceed in absentia. And then the bondsman shall surrender the accused to the court for execution of the final judgment. So the original paper shall state the full name and address of the accused, amount of the undertaking, and the conditions herein required. Also, when you post the bail, na photographs can passport size taken within the last 6 months showing the face. The left and right profiles of the accused must be attached to the bail. Okay? So, obligasyon sa bondsman nga isurrender ang accused to the court for execution of the final judgment. And for the purpose of surrendering the accused, the bondsman may arrest him or upon written authority endorse on a certified copy of the undertaking, cause him to be arrested by a police officer or any other person of suitable age and discretion. And then also remember, accused release on bail may be rearrested without necessity of a warrant if he attempts to depart from the Philippines without permission of the court where the case is pending. If you're on bail, kailangan manangihid ka sa korte kung mulagawas ka sa natson. Okay? And then the authority of the bondsman to arrest or cause the arrest of the accused springs from the old principle that once the obligation of bail is assumed, the bondsman or surety becomes the jailer of the accused and is subrogated to all the rights and means which the government possess to make his control over him effective. Okay. And then, all right. So basically, remember the conditions of bail provided for in Section 2. We now go to Section 3. In Section 3, no person under detention by legal process shall be released or transferred except upon order of the court or when he is admitted to bail. Okay? Hindi na pwede, no? Kung may court order or kung wala siya ma-admit to bail. Okay? Now let's go to Section 4. Kanus ama ng bail a matter of right. Okay? When is bail a matter of right? So tanawa ni, importante kayo ni, there was 1 or 2 bar exams wherein ang pangutana, one is bail a matter of right, one is bail a matter of discretion. Okay? So all persons in custody shall be admitted to bail as a matter of right with sufficient sureties or released on recognizance as prescribed by law or this rule before or after conviction in the MTC. Tanawa ha? Bail is a matter of right before or after conviction in the MTC, and bail is a matter of right before conviction in the MTC and provided ang offense is not punishable by death, reclusion perpetua, or life imprisonment. Okay? Ganihan ingon gyud the general rule is that tanang persons in custody shall be admitted to bail as a matter of right. Okay? And as a result, all criminal cases in the MTC are bailable as a matter of right because these courts have no jurisdiction to try cases punishable by death, reclusion perpetua, or life imprisonment. If you can remember, 6 years below mo na ilaha, diba? Likewise, bail is a matter of right prior to conviction by the RTC for any offense not punishable by death, reclusion perpetua, or life imprisonment. So, here, if you can see in the illustration, before conviction in the MTC, bail is a matter of right. After conviction in the MTC, bail is a matter of right. Okay? So, abot ni mo sa RTC, before conviction na tanawa. Before conviction in the RTC, unya ang offense niya dapat dili punishable by death, reclusion perpetua, or life imprisonment. Okay? Example, kung si Nico is accused of homicide, he is entitled to bail as a matter of right before his conviction since ang penalty anang homicide is only reclusion temporal. Okay? But if he is convicted, his admission to bail now becomes discretionary on the part of the court. Okay? And a example, a person accused of parricide or murder, kana sila they are not entitled to bail as a matter of right. Kay ang offense is punishable man by reclusion perpetua. So they have to apply for petition for bail. Diri musod ang bail as a matter of discretion and they need to prove that the evidence of guilt is not strong. Okay? Now, unsa kay mahimo nimong remedyo kung ang bail is denied? The remedy of a petitioner from the order of the trial court denying an application for bail is to file a petition for certiorari if the trial court committed grave abuse of discretion amounting to excess or lack of jurisdiction in issuing the said order. Okay? When we talk about certiorari, remedy na siya to annul the order of a court denying petition for bail. If we talk about mandamus, pwede sa na siya. And it may be availed of to compel the grant of bail, which is a matter of right. And when a bail is a matter of right, the court is left with no discretion but to grant the same. Okay? So, pwede mandamos kung i-deny mo right to bail. And then, remember that the right to bail, if the right to bail is a matter of right, the same cannot be denied, and the probability that the accused will escape or not appear in trial is not a ground for denial of the right to bail. It is, however, a reason for the court to increase the bail bond to assure his appearance. So, in one case, it was ruled that when a bail is a matter of right, The existence of a high degree of probability that the defendant will abscond confers upon the court no greater discretion than to increase the bond to such an amount as would reasonably tend to assure the presence of the defendant when it is wanted, and such amount to be subject, of course, to the provision that excessive bail shall not be required. So kung tanaw nimo, flight risk ang person nga mo post og bail as a matter of right, you have no right as a judge to deny it. What the judge should do would be to increase the amount of bail, but of course without also forgetting the provision that no excessive bail shall not be required. Okay, so timan ina bail as a matter of right before, after conviction in the MTC, and before conviction in the RTC for offenses not punishable by death, reclusion perpetua, or life imprisonment. Kung ang offense here after conviction kaning sa ikaduha nga part here, okay, so after conviction here in the RTC, no, bail becomes a matter of discretion. Kung makumbikto ka in the RTC for this part, ang bail nimo becomes a discretion. Another instance wherein bail becomes a discretion is before conviction in the RTC for an offense punishable by death, reclusion perpetua, or life imprisonment. So ang punishment, imposable penalty provided for by law is death, reclusion perpetua, or life imprisonment. Before conviction, bail is a matter of discretion, provided that the evidence of guilt is not strong, okay? Is not strong. How about after conviction and the offense is punishable by either death, reclusion perpetua, or life imprisonment? Is bail a matter of right or a matter of discretion? Neither, okay? Kaya kung after conviction, ang pasabot na ana, the evidence of guilt is strong, so you can no longer post bail as a matter of discretion. Okay, I hope that's clear. So mone, when is bail discretionary? Upon conviction by the RTC of an offense not punishable by death, reclusion perpetua, or life imprisonment, admission to bail is discretionary. The application for bail may be filed and acted upon by the trial court despite the filing of a notice to appeal, provided it has not transmitted the original record to the appellate court. However, if the decision of the trial court convicting the accused changed the nature of the offense from non-bailable to bailable, the application for bail can only be filed with and resolved by the appellate court. And then read the instances wherein kanus-a, mag-cancel ang bail, kini recidivist, previous escapee, and then committed an offense under probation, and then indicate probability of flight, and then undue risk that he may commit another crime. Okay, so just read those. Section 6 provides that a capital offense is an offense which, under the law existing at the time of its commission and of the application of the admission to bail, may be punished with death. Okay, so capital offense of an offense punishable by reclusion perpetua or life imprisonment. Here, the rules provide that no person charged with a capital offense or an offense punishable by reclusion perpetua or life imprisonment should be admitted to bail when the evidence of guilt is strong, regardless of the stage of the criminal prosecution. So muna kong giingon ganiha, okay? And then the burden of proof in bail application. The hearing of an application for bail filed by a person who is in custody for the commission of an offense punishable by death, reclusion perpetua, or life imprisonment. The prosecution has the burden of showing the evidence of guilt is strong. And then the evidence presented during the bail hearing shall be considered automatically reproduced at the trial, but upon motion of either party, the court may recall this witness for additional examination unless the latter is dead outside the Philippines or otherwise unable to testify. Okay? So, basahan lang na ninyo guys, that's basically self-explanatory. And then kani, amount of bail, guidelines on the amount of bail, you also read this. And then here, if you can see the provision, no, excessive bail shall not be required. Okay, so muna siya ang mga guidelines in awarding or in granting the issuance or the grant to bail. Okay, and then kung sa manang corporate surety. Okay, when we talk about corporate surety, this pertains to any domestic or foreign corporation licensed as a security in accordance with the law and currently authorized to act as such and may provide bail by a bond subscribed jointly by the accused and an officer of the corporation duly authorized by its board of directors. And then Section 11, property bond. Asa man na, a property bond is an undertaking constituting as lien on the real property given as security for the amount of the bail. Within 10 days from the approval of the bond, the accused shall cause the annotation of the lien on the certificate of title on file with the Register of Deeds if the land is registered or if unregistered sa registry book, no, on the space provided therefore in the registry of deeds for the province or city where the land lies, or in the corresponding tax declaration in the office of the provincial, city, and municipal assessor concerned. And then, these are matters of reading. Deposit sa cash. Remember lang, if it's a surety bond, di na mauli nimo if the accused is found innocent. But if it's a cash bond, property bond, mauli pa na ako innocent si if pamatud-an na not guilty si accused. Okay? These are matters of reading, and then kani, basahan lang ninyo guys. This one. And for feature of the bond, these are matters of reading. Basically, importante anigit katong when is bail a matter of right, when is bail a matter of discretion. Okay? Aning section 24, tanawa, no bail shall be allowed after the judgment of conviction has become final. Kung final na, wala na. Okay? If before such finality, the accused has applied for probation, he may be allowed temporary liberty under his bail. When no bail was filed on the accused or the accused is incapable of filing one, the court may allow his release on recognizance to the custody of a responsible member of the community. In no case shall bail be allowed after accused has commenced to serve a sentence. Okay? Timan ina. Okay, kani pong section 26, remember this, nga bail is not a bar to objections on illegal arrest, lack of or irregular preliminary investigation. So on application, according to this section, an application for or admission to bail shall not bar the accused from challenging the validity of his arrest or the legality of the warrant issued therefore, or from assailing the regularity or questioning the absence of a preliminary investigation of the charge against him, provided that he raises them before entering his plea. The court shall resolve the matter as early as practicable, but not less than the start of the trial of the case. Okay, so kana application or admission of the accused to bail shall not bar him from challenging both the validity of his arrest or the legality of the warrant issued therefore, provided that he raises them before entering his plea. It shall not likewise bar the accused from assailing the regularity or questioning the absence of a preliminary investigation of the charge against him, provided the same is raised before he enters his plea. So tanan iya gyud erased before the entry of plea, okay? Meaning before iyang arraignment. So the court shall resolve the matter as early as practicable, but not later than the start of the trial of the case, okay? All right. Any additional rules under the revised guidelines for continuous trial in criminal cases? So remember, petition for bail filed after the filing of the information shall be set for summary hearing after arraignment and pre-trial. Testimony of a witness in petition for bail may be in the form allowed by the revised guidelines, provided that the demeanor of the witness is not essential in determining his or her credibility. Petition for bail shall be heard and resolved within a non-extendable period of 30 calendar days from date of the first hearing, except in drugs cases which shall be heard and resolved within 20 calendar days. without need of oral argument and submission of memoranda, consistent with the summary nature of the proceeding. Now, motion for reconsideration on the resolution of petition for bail shall be resolved within a non-extendable period of 10 calendar days from date of submission of the motion. Okay? So I hope bail provisions on bail are clear. Let's now go to the rights of the accused. Okay? Okay. Kining rights accused naani sa inyong constilo, and when you will go through your Constilo 2, I think, you'll be discussing in depth the provisions on the Bill of Rights. Extensive kayo yung discussion ani, and atong discussion would be limited lang or confined to selective rights or to selected rights of an accused. Okay, so timan na this rule enumerates the rights of the accused at the trial. Okay, naagi na diha no, pasiuna anak niya is niingon in all criminal prosecutions, meaning trial na. Okay, the accused shall be entitled to the following rights: una, to be presumed innocent until the contrary is proved beyond reasonable doubt. Katungod na niya no, ayaw sa ninyo gikondenar ang tao, binadakpan na pareha atong diri sa suspitsado diri sa katong oro sa to oro Sugbo nga tindahan no, na ay mga robbers ato, and then someone was actually arrested. In fact, when he was arrested, he was still waiting for the results of the bar, and then recently when the results were released, it was found out na apil ang pangalan. And people were already condemning him na, uy, kuan man barrister, pero ngano naman nangawat naman So we have to remember the presumption of innocence. No, that's one of the rights of the accused. So to be presumed innocent until the contrary is proved beyond reasonable doubt. Also, to be informed of the nature and the cause of the accusation against him, iyan ang katungod, and to be present and defend in person and by counsel at every stage of the proceedings, from arraignment to promulgation of judgment. The accused may, however, waive his presence at the trial pursuant to the stipulation set forth in his bail, unless his presence is specifically ordered by the court for purposes of identification. The absence of the accused without justifiable cause at the trial of which he had notice shall be considered a waiver of his right to be present thereat. So when an accused under custody escapes, he shall be deemed to have waived his right to be present on all the subsequent trial dates until custody over him is regained. Upon motion, the accused may be allowed to defend himself in person when it sufficiently appears to the court that he can properly protect his rights without the assistance of counsel. Okay? Sana, sunod niyang katungod to testify as a witness in his own behalf, but subject to cross-examination on matters covered by the direct examination. His silence shall not in any manner prejudice him. Okay? And then to be exempt from being compelled to be a witness against himself, morning right against self-incrimination. And then to confront and cross-examine the witnesses against him at the trial. So either party may utilize as part of its evidence the testimony of a witness who is a deceased, out of or cannot with due diligence be found in the Philippines, unavailable or otherwise unable to testify, given in another case or proceeding, judicial or administrative, involving the same parties and subject matter, the adverse party having the opportunity to cross-examine him. Also, do na siya katungod to have compulsory processes issued to secure the attendance of witnesses and production of other evidence on his behalf. To have speedy, impartial, and public trial, and to appeal in all cases allowed in the manner prescribed by law. Okay? Nagikan ni sa Constitution nga niingon, in all criminal prosecutions, the accused shall be presumed innocent until the contrary is proved. Katong primero. Okay? So, remember that it is well established in jurisprudence that the prosecution bears the burden to overcome such presumption. Katong presumption nga innocence, no, until the contrary is proved, no, the the burden is on the part of the prosecution to overcome such presumption. And in doing so, it must rely on the strength of its own evidence and not on the weakness of the evidence presented by the defense. Maningkamot ng prosecution nga maprobar niya ang guilt sa akusado beyond reasonable doubt. Okay? If the prosecution fails to discharge this burden, the accused deserves a judgment of acquittal. Okay? So, timan-in nga quantum of proof, no? Every criminal conviction requires of the prosecution to prove two things. The fact of the crime, that is the presence of all the elements of the crime for which the accused stands charged, and the fact that the accused is the perpetrator of the crime. Okay? Dapat iyang maprobar ang tanang element sa crime. Ikaduha, dapat maprobar niya nga akusado mao gyud perpetrator sa crime. All these must be proven beyond reasonable doubt. Bisan gamay nga doubt, wala gyud dapat mahabilin. Okay? Proof beyond reasonable doubt does not mean such a degree of proof as excluding possibility of error produces absolute certainty. Moral certainty only is required, or that degree of proof that produces conviction in an unprejudiced mind. Okay? So, mauna siya ang asabot sa proof beyond reasonable doubt. All right? We also have the so-called equipoise rule. Okay? Equipoise rule. Okay? Timan nga the presumption of innocence has given rise to a jurisprudential rule referred to as the equipoise rule, which is well settled in this jurisdiction and which is a consequence of such presumption. So the application of the rule is triggered by a situation where ang court is faced with conflicting versions of the prosecution and the defense, okay? And where the evidence, the facts and circumstances are capable of two or more explanations, okay? Ang usa, consistent with the innocence of the accused, ang usa pod consistent with his guilt. So basically equal ang level ba sa iyahang presumption, ang weight sa presumption. So this situation cannot fulfill the test of moral certainty and is not sufficient to support a conviction. So the court then in this case will have to resort to the equipoise rule. So when we talk about the equipoise rule, this provides that where the evidence in a criminal case is evenly balanced, okay, balanced, the constitutional provision of innocence tilts the scale in favor of the accused. Okay? So kung in-ana ang situation, pareha nga ang ebidensya equal ba? Ang innocence and guilt equal. So jurisprudence would say that we apply the equipoise doctrine or the equipoise rule. We tilt in favor of the innocence of the accused. Okay? So remember that if the exculpatory facts and circumstances are capable of two or more explanations, one of which is consistent with the innocence, so courts should be guided by the principle that it would be better to set free 10 men who might probably be guilty of the crime charged than to convict one innocent man for a crime he did not commit. So under these circumstances, the presumption of innocence must prevail and the court must acquit. Okay? Remember, however, that no equipoise if the evidence is not evenly balanced. Kung dili balance, di na mo-apply ang equipoise rule, okay? Said rule is not applicable where the evidence presented is not equally weighty, okay? So the equipoise rule cannot be invoked where the evidence of the prosecution is overwhelming. But any doubt shall be resolved, of course, in favor of the accused. Mo gina atong pabor at gis akusado. Mo lagi, yung Supreme Court mas maayo nga atong buhian ang napo ka mga guilty ka mga tao kaysa atong bilangguon ang usa ka inosente nga tao, diba? So basically mo na giprotektaan gyud sa ato ang jurisprudence and our laws, okay? Okay. In order to inform the accused of the nature and the cause of the accusation against him, it is necessary nga ang complaint or information must contain those matters required by the statute or by the rules of court. Unsa man dapat state nimo ang name and surname of the accused, naagi ni siya sa katong Rule 1110 ninyo. State also the name and the surname of the offended party or iyang affiliation, di ba? And then state with sufficient clarity and in ordinary and concise language the acts or omissions constituting the offense to enable the accused to know the offense he is being charged with. Okay. Also, in ordinary and concise language, to state the qualifying and aggravating circumstances attending the acts imputed to the accused. Kaya ba naman mo aning qualifying and aggravating, di ba? Qualifying, imbes homicide, mahimong murder, di ba? Imbes theft ra, qualified theft. Imbes rape ra, qualified rape. Okay, these are some of the qualifying circumstances. And you have studied this in your criminal law 1. Aggravating, the effect would be to increase the penalty imposable against the accused, diba? So, i-appeal yun in ordinary and concise language. Also, another thing, to sufficiently allege that the crime was committed or its essential ingredients occurred at some place within the jurisdiction of the court. And then to allege the date of the commission of the acts or omissions constituting the offense, and which date may be one as near as possible, except kung ang precise date is a material ingredient of the offense. Example, kanang infanticide, okay, below 3 days old. So you have to establish the particular date when the crime is committed. Also, in offenses against property, if the name of the offended party is unknown, and the property must be described in which particularity to properly identify the offense charge. Okay? All right. So ato ko na ning tagsa-tagsaon. Let's try to see, no? So question, pwede ba nga ang akusado makonbikto for violation of BP 22 if the check described in the information is not the check allegedly issued and admitted in evidence? Kiba man yung BP 22, no? Kaning batas pambansa bilang 22 or the Anti-Bouncing Check Act, no? Question, can the accused be convicted for violation of BP 22 kung ang gipresentar nga check sa information lahi sa check nga iyang gipresentar during trial? Okay? In the case of Dico versus Court of Appeals, New Supreme Court, the accused here was charged with 3 counts of violation of BP 22 involving, among others, the check number, butang talang check number 1, check number 2, check number 3, okay? And during his appeal, niadto siya Supreme Court following his conviction by the lower courts, and then the Supreme Court discovered a discrepancy between the check marked as exhibit and the check described in the information, okay? And the information filed by the prosecutor described the check as check number 1, okay? Pero the prosecution, however, marked as its exhibit check number 4, okay? Not check number 1, dated May 12, 1993, in the amount of 100,000 pesos payable to Equitable Banking Corporation. So instead of check number 1, ang ilang pamarkahan, ang check number 4 may napamarkahan, lahi kayo. So the issue as to the identity of the check, though not raised as an error, should, according to the court, be considered in favor of the accused. Okay, the variance in the identity of the check nullifies the conviction of the accused. The identity of the check enters into the first element of the offense under Section 1 of BP 22, that a person draws or issues a check on account or for value. So there being a discrepancy in the identity of the checks described in the information and that presented in court, petitioner's constitutional right to be informed of the nature of the offense charge will be violated if his conviction is upheld. So, anak ka-importante, nung muna pasabot sa the accused should be informed of the nature and the cause of the accusation against him. So, kung unsa gibutang sa information in the complaint, it should be consistent kung unsa imo ebidensya i-present during the trial. Otherwise, kani nga katungod will be violated. Okay? Also, in one case, ningon ng Supreme Court, no, where the judge set a criminal case for arraignment and hearing, knowing fully well that no preliminary investigation has been conducted and no information has yet been filed before his court, he justified his action as pursuant to his judicial function as presiding judge. The Supreme Court declared said act as having clearly violated the right of the accused to due process and to be informed of the accusation against him and to have a copy of the information before arraignment. Okay. And then in one case, no, there was one case wherein the petitioners were charged with violation of Anti-Carnapping Act of 1992 before the RTC of Malolos City, Bulacan. So here, ang information did not allege that the supposed felonious act of the petitioners was committed by means of violence against or intimidation of any person or force upon things. In other words, the information was only for simple carnapping, and the penalty for which, under Section 14 of the law, shall not exceed 17 years and 4 months. So after trial, ang mga petitioner here were sentenced to suffer the penalty of 17 years and 4 months to 30 years imprisonment. So that's a penalty in excess of that provided for in simple carnapping. So here, the penalty meted is actually equivalent to the imprisonment imposable when the carnapping is committed by means of violence against or intimidation of any person or force upon things. So ngayon ang Supreme Court, mo-agree may sa mga petitioner nga ningon sila nga erroneous ang penalty ang gihatag sa ilaha. The Supreme Court noted that the information charging the petitioners with violation of RA 6531 or the Anti-Carnapping Act of 1992 as amended did not allege that the carnapping was committed by means of violence against or intimidation of any person or force upon things. While these circumstances were proven at trial, they cannot be appreciated because they were not alleged in the information. Okay? Timan ina ka-importante, they were not alleged in the information. Thus, the lower courts erred when they took these circumstances into account in imposing the penalty, which they pegged at 17 years and 4 months to 30 years of imprisonment. In the absence of these circumstances, the charge against the petitioners is confined to simple carnapping, which imposable penalty should have been imprisonment of not less than 14 years to not more than 17 years and 2 months. Kaya mo naging sa Supreme Court in Andres versus People. Now, another case that you can see in your book, no? Tara diha. Thus, conviction for the sale and possession of methamphetamine hydrochloride or shabu violated the accused's constitutional right to be informed of the nature and cause of the accusation against him if the fact was established and proven during trial was the sale and possession of ephedrine, a regulated drug. Okay, so how did the Supreme Court answer that? In the Supreme Court, we rule in the negative. Okay, the chemical formula of ephedrine, which is C10H10NO, whereas that of methamphetamine is C10H15N. The only difference between ephedrine and methamphetamine is the presence of a single atom of oxygen in the former. So the removal of the oxygen in ephedrine will produce methamphetamine. So with ephedrine containing 50% of methamphetamine hydrochloride, if the oxygen content in the former is removed, the nearly 680 grams of ephedrine seized from the appellant contains about 340 grams of methamphetamine hydrochloride. So naara ko nagyapon, okay? In other words, his right to be informed of the charges against him has not been violated because where an accused is charged with a specific crime, he is duly informed not only of the specific crime but also of the lesser crimes or offenses included therein, okay? And then kaning right to counsel, okay? Right to counsel. If naka-remember mo ganiha, we have mentioned about the rights of the accused, no? And the Bill of Rights guarantees the right of counsel to an accused, okay? And there's rules also, the accused has the right to defend in person and by counsel at every stage of the proceeding, from arraignment to promulgation of judgment. The right to counsel proceeds from the fundamental principle of due process, which basically means that a person must be heard before being condemned. Okay, the due process requirement is part of the person's basic right. It is not a mere formality that may be dispensed with or performed perfunctorily. Okay. Um, Also remember nga dili necessary na akusado ka in order to avail of the right to counsel, and the right to counsel does not commence only during the trial. Okay, every person under custody of the law enjoys the right to counsel. Okay, in fact, in RA 7438, namely diha nga any person arrested, detained, or under custodial investigation shall at all times be assisted by counsel. So even a person under investigation for an offense has the right to have a competent and independent counsel, preferably of his own choice. Okay? So naana siya, usa na siya sa mga Miranda rights. Okay? So to have an independent and competent counsel. Now, unsa may pasabot ng competent and independent counsel. Okay? Napangutana sa siya sa bar before, no? So, the Supreme Court said that a lawyer called to be present during such investigation should be, as far as reasonably possible, the choice of the individual undergoing questioning. So, as much as practicable, yun ang Supreme Court, choice gyud dapat sa akusado. Okay? If the lawyer were one furnished is in the accused's behalf, it is important that he should be competent and independent. That is, he should be willing to fully safeguard the constitutional rights of the accused, as distinguished from one who would be merely giving a routine, peremptory, and meaningless recital of the individual's constitutional rights. Okay? In one case, the Supreme Court stressed that an accused's right to be informed of the right to remain silent and to counsel contemplates the transmission of meaningful information rather than just the ceremonial and perfunctory recitation of an abstract constitutional principle. Okay? Ideally, therefore, a lawyer engaged for an individual facing custodial investigation should be engaged by the accused or by the latter's relative or person authorized by him to engage an attorney or by the court. Okay? Kanang mga lawyers engaged with the police, whatever testimonials are given as proof of their probity and supposed independence, are generally suspect. As in many areas, the relationship between lawyers and law enforcement authorities can be symbiotic. Okay? So, ideally good, kung mga mga abogado, kanang kamod kayo nagkuha o kanang inyo ba pamilya ang nagkuha. Okay? Ayaw kayo mo, no offense meant to the police officers, but not those ng mga gi-refer sa mga police. Okay? The competent or independent lawyer so engaged should be present from the very beginning to the end. Okay, that is at all stages of the interview, the counseling or advising, mga caution reasonably at every turn of the investigation, and stopping the interrogation once in a while, either to give advice to the accused that he may either continue, choose to remain silent, or terminate the interview. Okay? And then napagingon ng Supreme Court, hindi kayo nun Supreme Court. The right to counsel must be more than just the presence of a lawyer in the courtroom or the mere propounding of standard questions and objections. The right to counsel means that the accused is amply accorded legal assistance extended by a counsel who commits himself to the cause for the defense and acts accordingly. So the right assumes an active involvement by the lawyer in the proceedings, particularly at the trial of the case. He's bearing constantly in mind of the basic rights of the accused. He's well versed on the case and is knowing the fundamental procedures, essential laws, and existing jurisprudence. The right of an accused to counsel finds substance in the performance by the lawyer of his sworn duty of fidelity to his client. Okay? Simply put, it means an efficient and truly decisive legal assistance and not a simple perfunctory representation. Okay? So I hope that's clear. And then we go to custodial investigation. Okay? When we talk about custodial investigation, this has been described as any questioning initiated by law enforcement authorities after a person is taken into custody or otherwise deprived of his freedom of action in any significant manner. Okay. So, in one case, when the appellant was brought to the police station, he was already a suspect to a crime of rape. As such, he was already under custodial investigation. So, when appellant remained silent when confronted by the accusation of X at the police station, he was exercising his basic and fundamental right to remain silent. And at that stage, his silence should not be taken against him. Therefore, it was error on the part of the trial court to state that the appellant's silence should be deemed as implied admission of guilt. Di na mao. Okay? In fact, in the Supreme Court, this right cannot be waived except in writing and in the presence of counsel, and any admission obtained in violation of this rule shall be inadmissible in evidence. Okay? And then you remember Republic Act 7438 has, however, redefined the concept of custodial investigation and has extended this constitutional guarantee to situations in which an individual has not been formally arrested but has merely been invited for questioning. Okay. So this act provides that custodial investigation shall include the practice of issuing an invitation to a person who is investigated in connection with an offense he is subject to have committed without prejudice to the liability of the inviting officer for any violation of the law. Okay. So, a request for appearance issued by law enforcers to a person identified as a suspect is akin to an investigation. Therefore, the suspect is covered by the rights of the accused while under custodial investigation. Any admission obtained from the request of appearance without the assistance of counsel is inadmissible in evidence. Okay. Kanang right to speedy disposition of cases and right to speedy trial. Okay. Timan nga akusado also has the right to speedy disposition of cases. But this is different from right to speedy trial, okay? Well, the rationale for both rights are the same, that is to prevent delays in the administration of justice. The right to speedy trial may only be invoked in criminal prosecutions against courts of law, okay? Muna, speedy trial support. The right to speedy disposition of cases, however, may be invoked before any tribunal, whether judicial or quasi-judicial or administrative bodies. Okay? So kanus aman nga ang right to speedy trial is deemed violated. The right to a speedy trial is deemed violated only when the proceedings are attended by vexatious, capricious, and oppressive delays, or when unjustified postponements of the trial are asked for and secured, or when without a cause or justifiable motive, a long period of time is allowed to elapse without the party having his case tried. So basically, ang word is vexatious, capricious, and oppressive delays. Kanang mga mo-leave si judge, it will not be considered as a violation to a speedy trial. Nag-ilis og korte, gibalhin ng case, nga na, nag-pandemic, it will not be considered as a violation of speedy disposition of case, okay? Or speedy trial, rather. And then, what else? Okay. So what is the effect then of the violation of right to speedy trial? So the trial court may dismiss a criminal case on a motion if the accused is not brought to trial within the prescribed time and is deprived of his right to a speedy trial or disposition of the case on account of unreasonable or capricious delay caused by the prosecution. There's also a permanent dismissal of a criminal case where the ground for dismissal is a violation of the right of the accused to speedy disposition or a trial of the case against him. So a dismissal based on the violation of the right to speedy trial is equivalent to an acquittal and attach na ang double jeopardy. So nindot kayo nga ground, no? If you will move for the dismissal of the case on the ground that the right of the accused to speedy trial has been violated, the effect would be a permanent dismissal and it is equivalent to an acquittal. If it's equivalent to an acquittal, on double jeopardy will now attach. Okay, there's already a first jeopardy, and if the prosecution would want to revive the case, pwede na kang ma-interpose nga your right against double jeopardy is actually violated. Okay. All right. I think those are the important things in the rights of the accused. Timan ilan na ninyo, no? Especially kanang right to speedy trial. It's very important to know the consequence of the right to a speedy trial. Okay.